basically, CETA is the Comprehensive Economic Trade Agreement between the EU and Canada. It's a trade agreement that was, provisionally applied since 2017. And something that's maybe for me, where I got interested in this issue, I was used to work with COLOV many, many years ago, and we looked at the kinds of trade deals that Europe was doing with a lot of African countries. And one of the elements that was a real problem was that they used the attachment of corporate courts. So corporations effectively bringing their own court system into trade deals with different countries. The Comprehensive Economic Trade Agreement has a lot of problems. I'm not going to talk about all of those aspects of it because a lot of them are already, the battle is over on those. But what's really important is the investor court system. When I was a new senator in 2016, my very first private members bill was a bill which said that in this trade deal, you can't look at the trade part and the investment court part together. They are separate and they're very significantly different. And that same decision was, upheld effectively by the 2017 judgment of the European Court of Justice, where they said, the European Union, the European Commission can negotiate on trade, but when it comes to investor court systems, that's a national decision. It has a huge impact on different individual countries, and they need to decide it for themselves. And the investment court system, that part of the CETA deal, that is a mechanism whereby it's a separate parallel legal system. It doesn't relate to our national courts. It doesn't relate to the European courts. It's a separate system of arbitration whereby if an investor feels that a new regulation or an area of policy or a decision that is made by a state is going to unfairly impact on their profitability, they can look for compensation. And in these investor courts, they can look for compensation, sometimes up to the amount of billions of euro, because something that's really notable is the courts, these arbitration will give compensation, not just for the money that a company might have lost in the immediate term, but for the future profits that the company can say it would have made if this new regulation hadn't come along and unfairly impacted it. That's the kind of summary of why this is so controversial and such a problem. As I said, the trade parts, they're already happening since 2017 under provisional application. But the decision being faced right now in Ireland is whether or not to take the next step in full ratification, and that requires a national vote to say we accept the investor court component, we accept the investor chapter of CETA. And there's two reasons that it's a problem. One is that we're bringing that kind of investor court system I've described, whereby corporations can create a huge pressure on governments. Not just the problem isn't just the awards that they may get. The problem is that the chill effect, the fact that a case might be taken, that the costs of the case will be expensive, that there is that potential cost, that creates a huge pressure on governments to maybe say, we want to rethink this regulation. Do we really want to create difficulties for ourselves by pushing forward with this environmental regulation? That's the kind of one real reason. The other reason, which is really important from an environmental perspective, is exiting something that you've provisionally applied is quite easy. So for example, if Europe and Canada could negotiate a new trade deal and decide to switch over to it while provisionally applying quite easily, once we've ratified, exiting will take 20 years because you have a 20-year zombie clause, which means that even if everybody involved in the deal wants to come up with something, or even if all of the European countries want to come up with something different, we are stuck for a 20-year zombie clause. So that's why it's really a significant thing to decide to go ahead and ratify. I could address maybe two or three of the myths that we've heard in the recent while. When we talk about, we've been told that, this is different, that there's reference to the environment, and that there's a whole chapter on the environment in the CETA clause. The chapters on the environment within the CETA agreement don't have any legislative teeth, whereas the chapter on investor protection has a lot of teeth and has a lot of power. And also, there was an addendum which was added to the CETA agreement, which talked about the Paris Agreement, and we've been told, that really is great and talks about Paris now. But that actual addendum that was added on doesn't have any legal power, first of all, And it actually doesn't talk about investors at all. It just talks about how Europe and Canada should cooperate, particularly around the expansion of trade opportunities in relation to the Paris Agreement. So you kind of have this chill, and it's really interesting in terms of the regulatory chill. I don't know how much detail to go on, but one thing that I've seen talked about is, you know, countries can still regulate, you have the right to regulate. The right to regulate is a red herring in this regard, because of course you can regulate. The question is, if you regulate, what will the consequences be? And that's where the chill effect comes in. And we have examples even now, and it's like climate legislation is the absolute front line in this. In France, there was a dilution of the climate laws because they were threatened with a potential case. So that's a real example. And we have other examples around the world, you know, even where countries, for example, tried to place moratoriums on fracking. For example, in Montreal, they were taken to court in relation to that. So there's a number of examples of huge awards that have been given in relation to environmental cases, but also where the chill effect has meant that governments have just backed down. And the section 8.9 in the CETA agreement, because I've seen it being quoted as saying, you know, that, you know, countries can regulate, etc. But it's really interesting. It treats regulations and subsidies differently. So in the section on subsidies, it says a government can stop giving a subsidy to a company, and that shouldn't require that party, the country, you know, to compensate the investor. In the section on regulations, it just says the mere fact that a country regulates or that a party regulates is not in itself a breach. So this is, again, that red herring issue, because the right to regulate is there, but there is also absolutely a right for the investor to seek compensation. And if they feel that they've been treated, what they call, if they've had unfair or inequitable treatment, and then everybody said that sounds really reasonable, but unfair and inequitable treatment is exactly the language that's been used in investor-state dispute cases all around the world. That is the kind of language that has been used to sue Ecuador. It's the kind of language that's been used, was used in terms of the Keystone Pipeline, you know, which that's a really interesting example whereby, I'll come back to that in a minute, but there's a number of examples all over the world. So that's kind of the chill effect. And I'm really worried and concerned about that as a legislator, because I already come up against the very real fact that anytime they feel there might be a case or there might be a legal case taken, we see it on housing, why they can't do better housing laws. They're always told that there might be a case, that we will have obstacles put in the way of good laws on the environment and on climate. And the chill effect, others have spoken really well about it. I don't know, but you know, they talk about it. It can be anticipatory, which is, you know, you don't do the law because you don't want to be sued. It can be responsive, where you back down on the law because you feel that you're, you know, because you're threatened with the case. It can be transnational, and we see sometimes companies take one case against one country, but use that case to pressure lots of other countries on their laws. They more or less say, we'll do to you what we are doing to them if you continue with this environmental or public good law. So that's one. But the other thing, and this is really important from an environmental perspective, I think there is an attempt, one of the reasons this is getting pushed now, to chill good environmental legal cases. So we've seen the amazing work done by Climate Case Ireland. And we saw, for example, you know, the Oireachtas case, and we've seen Indigenous groups and youth groups all around the world who are really pushing governments on environmental laws and taking them seriously and holding governments to account and creating a legal pressure on the political system. And I worry that the investor court system is going to be used to create a counter legal pressure, one with very, very expensive price tags attached, to undermine that impact of citizen legal action. So that's a little bit all about that. There's an intergenerational issue here. There's an intergenerational justice issue, because you know, all of you who are interested in politics and who may wish to be legislators in the future would be affected by this decision. And that's really important, because, you know, we want a government, it's, you know, it's not just about this government and what they do or don't want, it's about the next 4, 5, or 6 governments and what they are able to do, and what the cost of what they would do it. And the way I think of it in climate, kind of been thinking about it in this way of, we are already so far behind in the race to act on climate change. And even though we're starting from so far behind, if we introduce this investor court system, we're taking that rate and making it an obstacle course. We're literally putting a brand new obstacle in our way in a race that we're already very far behind on. And that's why I think one of the really important issues is, even if you were to do such a thing, introduce these mechanisms, to introduce them right now, when we need to make so many new laws on climate and environment, is really foolish. I'm going to leave over to others. The last thing I would just say is, this isn't inevitable, and it's a really positive thing, is the tide is going out on this kind of deal. This is a last blast of an old model. And like with Mercosur and CETA, they're almost like the last big crumbling pillars of an old model of trade. But the new trade deals, the UK-EU trade deal, the EU-China trade deal, and the new US, Canadian, and Mexican deal that's replaced NAFTA, they don't include investor arbitration, or they include very little investor arbitration. They've really tried to say, why are we, if the parties, as they call them, the EU and Canada, or the EU and the UK, if we're signing a deal between us, why are we giving these companies that have no obligations or duties under the treaty all of these additional random powers? So that for many of those deals now, arbitration is limited to the people who've actually signed the treaty, to the parties, to the countries that have actually signed up to the deal. And that's really important. And that's why the tide is changing. And it's the Energy Charter Treaty, which has been renegotiated in March, is one of the last big dangerous monoliths. And we have now that France and other countries saying we need to change the Energy Charter, because otherwise fossil fuel companies will directly get in the way of the transfer to renewable energy. So I think the landscape is changing.